Yeah. So, uh, well, no, let me at the very outset mm, welcome you all. Those are joining the live streaming, and of course, the whole panel. We have with us as being readily accepted by Dr. Raja Sekhar Vundru. Sir is a very senior IAS officer and presently serving as Additional Chief Secretary in the Government of Haryana. And also we have with us Dr. Rehnamol Raveendran, who is uh, presently a faculty assistant professor in the Department of Political Science of University of Allahabad. And we also will be joined in a minute or so, or maybe in some time, by Arvind Kumar. Arvind is an assistant professor at Royal Holloway, University of London. Uh, he is with the Department of Criminology. And I welcome all of you. I welcome Sair, I welcome Rena for agreeing to be part of this panel discussion. And as you all know that we are going to discuss this whole, in the context of the judgment that was passed by the Supreme Court seven judges bench, led by the Chief Justice of India, D.Y. Chandrachud, which basically had, in a majority judgment, declared that the SC/ST basically reversed the E.V. Chinnaya judgment of five judges constitution bench, which was rejected and reversed by the seven judges bench led by Chief Justice of India. Uh, and there were six other judges: Justice Gawai, Justice Mittal, Justice Misra, Justice Sarma, and of course Justice Bela Trivedi. Justice Trivedi and Justice Nath. Justice Bela Trivedi gave a dissent judgment, a single dissent judgment, and agreed with E.V. Chinnaya, and she said that E.V. Chinnaya judgment cannot be altered. So, Dr. Chandrachud, Chief Justice of India, has written the majority judgment. The other six judges accepted that judgment, and of course went against the E.V. Chinnaya judgment of the five judges bench. So, what has happened is that post that judgment on August 1st, there has been a huge uproar on the way the subclassification was basically discussed, and of course, as a verdict came out, and how the states were empowered by the Supreme Court of India to subclassify. And then, post that judgment, there have been many academic interventions and academic differences on the judgment, which basically, on various notes, are trying to discuss and probably also critique that judgment on several points. There have been so many academics and activists; those have written back-to-back articles on the ideas of subclassification, how the subclassification basically goes against the constitutional mandate, where the Article 341 and 342 specifically are mandating the Parliament and then the President of India to make the lists of the scheduled castes and scheduled tribes. So, if you all have looked at the the judgment of the Justice Chandrachud, he continuously talking about on various operative portions, on various points. He's promoting an idea of substantive equality within the reservation, where it is coming out that within the scheduled caste specifically, a scheduled tribe was not in the mandate of this bench, but even though there was a judgment, there was no party from the scheduled tribes side. There was no lawyer which deposed before the bench. Even the National Commission for ST was not involved. as a very, very important nodal agency for the scheduled tribes. So was the case with the National Commission for Scheduled Caste, where it is said that the Solicitor General of India and the Attorney General of India kind of went ahead supporting the subclassification of the SC/STs, where the National Commission for Scheduled Caste was not really taken on board, and also that there was no SC/ST. They did not discuss with the SC/ST MPs and so on. So 2 points I'll mention, and then we'll just hand over and we'll proceed with the discussion. One more point which has come in a very, very big way is that economic backwardness as opposed to the social backwardness. I myself have written an article where I talked about that this judgment has failed to take into cognizance the social backwardness of the SC/STs, which is the bedrock of this entire reservation, where things like historical untouchability, the 10 points parameters, to recognize this. So the point of discussion which came into contention was on the homogeneity and heterogeneity of the SC/STs, whether the SC/ST list as the senior lawyer, senior advocate Sanjay Hegde said during the hearing, he said that this entire SC/ST reservation is on the, especially the scheduled caste reservation, is on the basis of untouchability. Since it has everyone who is in that list has a tint of untouchability. How untouchable one is cannot be measured. So it is the tint of untouchability that makes that entire community as a homogeneous community. And on the other hand, he said, along with K.S. Chauhan, who opposed subclassification, another senior lawyer, they said that the Indra Sahani judgment, which came in this 7 judges bench led by Justice Chandrachud, where they said that there is a Indra Sahani judgment was referred, but Indra Sahani judgment broadly was about OBCs, that it doesn't take into cognizance about the SC/ST matter. So SC/ST reservation has a historical basis, and that basis is on the basis of untouchability and historical caste-based discrimination. So there is nothing called economic upwardness or backwardness. Even Professor Thorad, prominent economist, has written an article in Hindu. He says that even if there is certain communities in the scheduled caste, if that goes upward, it is the capital ownership which should decide. And capital ownership, according to him, he says that it has to be evenly distributed by the government. Government fails here, and government has to take into cognizance this. So overall, this judgment is a judgment where on which there has been a 21st August Bharat Bandh call has also been given, and a judgment which is probably not taking into cognizance so many matters, right from social backwardness, right from Pune Pact, the whole struggle that Dr. Ambedkar fought for the scheduled caste reservation and so on. So this is a whole, I would say, Pandora's box that has been opened due to this judgment, and probably there are several state governments, those have gone ahead to support this, and they said that, for example, Karnataka government, the Haryana government, and so on. So they went ahead to kind of subclassify this SC/ST list. So this was in fact the whole potential hunch of the people, those actually are opposing, that the states can use SC/ST lists for their own political purposes, and there can then be a balkanization, as Sanjay Hegde says, of the SC/ST lists. It is not about that all the states are like the big states. There are small states like Manipur. We all know what happened there after a high court judgment and so on. So it actually creates gives us so many points to discuss. So I wouldn't talk much. Without further ado, I would rather request Raj Sekhar sir to basically deliver his take on the whole historical injustices faced by the Scheduled Caste, Scheduled Tribe communities, and the kind of what I call as a very, very reductionist jurisprudence that has evolved with regards to the SC/ST, reservation, and this in the context of this subclassification judgment, sir.
Thank you, Subhajit, and thank you, Rehnamol ji. I hope Arvind joins soon. In fact, this is a. Hope I'm audible.
In the context of this subclass. Yes, sir. Yes, sir. You are.
See, this particular judgment opens up too many things for the scheduled castes, especially, where it hits at the very roots of the. It hits or examines or it tries to evaluate and tries to kind of bare expose the very basis of scheduled castes being listed, various castes being listed as a scheduled caste. We all know the history. There are, for the purpose of categorization, in 1975, Punjab government did a classification. It is even not a classification. We can call it a grouping, where the Punjab government made two groups. One is the Chamar, Ravidasi, Adharmi, who were very well educated and very in jobs. And other one is Majbi Sikh and Balmiki, similar castes, who are not able to access jobs in that way, in that numbers. So the arrangement in Punjab was that it's like an open and a flexible subgrouping. For example, in the Balmiki or Majbi Sikh, if the candidate is not available, because at that time their educational progress was not that much, then the post will be filled up by the other group of Chamar, Ravidasi or Adharmi groups, which were in a part of Punjab, which was British ruled, so they were better educated. So there was a flexible arrangement. Briefly, I will touch upon. So after some time, around the year 98, 99, when Telugu Desam Party came into power, Telugu Desam Party, for political reasons, decided to regroup them. It was very clear that they were doing it for political reasons. And they formed a commission called Ramchandra Raju Commission. And they passed actually a law, the legislation dividing them into 4 groups, which is a very ridiculous method of way of dividing them. And there was it is so ridiculous, I am comparing with Punjab. It is so ridiculous that there was during the Adi movements, everybody renaming themselves, caste renaming themselves as Adi Andhra, Adi Dravida, Adi Karnataka, Adi Hindu. This kind of a movement was going on since 1930. So there was a community, some of the castes, like Malas and both Madigas, they called themselves Adi Andhra as a progressive movement. So when the census evaluated them, very few returned themselves as Adi Andhra. But Adi Andhra, being from the coastal part of the Andhra Pradesh and very well educated under the British government, were having good number of access to good number of jobs. The Telugu Desam government gave them 1% reservation, which is a very funny way of subgrouping. 1% reservation means if at all the government fills up 100 jobs, which would be very rare, they will get 1 job. So the stretch and the extent of subgrouping. So the word categorization came for the first time from Andhra Pradesh. We all know that it went on to E.V. Chinnaya, a very, very famous activist and an author, Yendluri Chinnaya, he led the case in the Supreme Court. High Court, of course, upheld the classification. Supreme Court set it aside on a 5-judge constitution, and Supreme Court said very far-reaching things. So when Supreme Court raised certain issues, that really stuck. Supreme Court said that they are homogeneous. And so when the case moves further now to a next level of a Supreme Court to decide it, they have to first of all decide whether it is homogeneous or a heterogeneous category. So whether they are homogeneous or heterogeneous category, one should actually trace back. In fact, the first ever evaluation, if we look at Dr. Ambedkar's book, Who Were Untouchables and How They Came to Be So, he refers to the 1911 census documents. So I also at some point in time went into and pulled out the 1911 document, where they were keen to, the census was keen to understand who were those people who are sort of, they didn't exactly call them untouchables at that time. They said that there are certain, to enumerate castes and tribes returned as classes of Hindus who do not conform to certain standard and are, I'm reading out of the 1911 census, and are subject to certain disabilities. So that means they are basically, later on in 1921, they were called 20 depressed classes. So the evolution of the word also, what are these people? So they were, the census commissioner or the superintendents went with certain tests. The 10 tests which said that who are those castes who deny the supremacy of Brahmins, who do not receive a mantra from a Brahmin or other recognized Hindu guru, they deny the authority of Vedas, they do not worship Hindu gods, they are not served by good Brahmins as family priests, they have no Brahmin peace at all, they are denied access to interior of the ordinary Hindu temples, they cause pollution by touch or even within a certain distance, they bury their dead, and they eat beef and do not show reverence to the cow. These were the 10 tests by which they tried to understand and bring in people. So single most important point here was the cause pollution by touch or cause pollution, that is untouchability, within a certain distance. So these were the numbers that they were gathering. In fact, on the other side, after the 1911 census data and after the 1921 census data, Ambedkar started insisting on, if you look at his 1919 document before the Southborough Commission, he actually pulls out data from the 1921 census. In fact, there was provincial data. By 1921, they called them depressed classes. So I am reading out of the 1921 census, where they were basically looking. They were basically. It says that I have in some cases modified the estimates information from 1911 tables. So the minimum numbers that may be considered to form, now here comes the word, depressed classes of the Hindu community. So he says that, this particular figure adds up to a particular number. He said there adds up to 53 million. 53 million. And so we may confidently place the numbers who are considered impure. So here the word of, and they put it between 55 to 60 million people who are considered as impure, and these are the depressed classes. Now this is how when a certain number of castes have been picked out, the castes and tribes have been listed, and they have been added to a kind of a estimate. The two things that they were actually looked at here are the one, they were a part of the Hinduism, or they called themselves Hindus, but they are impure and they are called depressed classes. Now comes the 1931 census. So in the 1931 census, eventually, of course, the scheduled castes were listed. The clarity came about in the 1931 census, and there was a presidential, there was called the Government of India Scheduled Caste Order 1936, which was issued on 30th April 1936. 30th April 1936. Now we have a whole gamut of list of castes. Now let us go to Madras province, where me and Rehnamol come partially. In the schedule 1, there are castes. This is called the uh, Government of India Scheduled Caste Order 1936. So it says, see, there is a schedule here. So those people are in the schedule will be called as scheduled caste. Now I have schedule which has part 1 Madras, Bombay, Bengal, United Provinces. These are the states added to Punjab, Bihar, and central provinces and Berar. These are the then Assam, Orissa. These are the caste lists, and it was signed by C.K. Rhodes, Joint Secretary to Government of India. Now these castes are a group of castes. Say for example, Madras says Adi Dravida, Adi Andhra, Adi Karnataka, Arundhatiyar. We go down the line. It says Hosala, Holaya, Jamboulu. Of course, it says Madiga, Madari, Malla, Mala, Maladasari. It goes like that. Panchama, Paniyan, Paniyadi, Parayan, Paravan, Pulayan. These are the castes. So what we have here is a grouping of castes. And what is the single line? What was the single line of this aggregation of this castes? Single line of the aggregation of castes is very clearly on the basis of untouchability that has been practiced, and these people are considered as impure. Now, unfortunately, the counter to the judgment of E.V. Chinnaya, where all the 5 judges unanimously agreed that they are homogeneous, we have a judgment at hand which suddenly, without any credible evidence or maybe a detailed study, so the earlier, the time between the previous study and the current one is like something like 20 years. In 20 years, there is no study or not available. Of course, so government should have, or the institution should have done it to try prove otherwise, that they are not homogeneous. Certainly, they are. When you look at the list, it says they are caste and tribes. So in those days, all the castes, or even the word is used called castes and tribes. Now let us come to a very interesting example. The fishermen in Orissa and Bengal are considered impure and they are untouchables. But you move from Orissa, Ganjam district, and get into Visakhapatnam district, just on a border, the fishermen are not considered untouchables. And you take a community by the name of Dhobi, in Uttar Pradesh, they are considered untouchables. And in most of the parts of the country, they are not considered untouchables. So this only proves to show that the people, the various castes in the list are for some reason or the other. Even Ambedkar tries to understand why certain castes who do not do any profession which are impure. For example, you're not carrying a dead cow, you are not skinning dead animals, you are not cleaning you're not cleaning the streets, or you're not cleaning sewers, which are considered as sort of impure. There is a natural be, natural behavior towards purity or impurity of people who are, say, holding dead animals or treating sewer. But he also understands why, say, a community like Mala, or a community like Holea, or certain communities who don't deal with impure occupations are also considered untouchable. For example, the best example is a Mala Holea continuity, where they don't do impure work, but they're still untouchables. So the clear understanding of the homogeneity of these communities is very clear that the Hindu society, for one reason or the other, in various parts of the country, for various reasons, treat these castes as untouchables. That is why they are there. If you even see the funniest part of uh, the 1936 order, of course, which basically carried, they even specify whether it is throughout the province. For example, in Bombay province, it says throughout the Bombay province except in Ahmedabad, Kaira, Panchmahal and Surat district, Mochi. That means Mochi in Bombay province, in Ahmedabad, Kaira, Panchmahal and Surat were not considered as untouchables. That is the census figures that have come. In fact, it is more pronounced in central provinces, where lot of castes were considered untouchable only in a limited area, in a particular taluk. So a simple reading of the scheduled caste order, or the way the aggregation of the scheduled caste have taken place, shows that solely, see, everybody, all of us say, all of us today, by now, a lot of people say. So the argument or the conclusion that they are not homogeneous is fallacious, unless and until it is proved by a detailed study. What are the detailed studies we have? Even after 1911, 1921 and 1931 census, we have anthropological studies by various census commissioners or various officers in the British India, where the Caste and Tribes of South India by Edgar Thurston, or Caste and Tribes of North India by Ibbotson. We have on Bengal. We have so many studies. Such information and data, when you look back into them also, it doesn't specify any reason that why they are not homogeneous. If the Supreme Court was of that opinion, it could have certainly asked the Anthropological Survey of India or anybody, or to do a study and to prove otherwise that E.V. Chinnaya was wrong. So merely on the basis of arguments of a bunch of lawyers that they are homogeneous or heterogeneous, one cannot, unfortunately, because the aggregation of certain castes as untouchables or impure or depured classes, now called scheduled castes, was on the basis of a long standing census operations of 11, 21 and 31. And they continued so. So one aspect that is very disturbing and it's very unfortunate, and which has come without any due consideration or study, is the conclusion arrived by the 6 judges out of the 7 judges of this judgment, that the scheduled castes are not homogeneous. Of course, one can understand they are heterogeneous because they are called by various names. Of course, they are called by various names. They are and they are so disparate, differentiated. They are they are all over the country, starting from Kashmir to Kanyakumari. So that is a very, very disturbing trend that has happened in the jurisprudence in this judgment. Suddenly telling a group of people they are a heterogeneous bunch of people. If the conclusion comes they are a heterogeneous bunch of people, then it can throw up into lot of interpretations. And the way Dr. B.R. Ambedkar said on 17th September 1949, when he made the last amendment to the Article 341, at that time it was called Article 300A in the Constituent Assembly, that he wants to avoid any political reasons to be crept into the dealing with the list of scheduled castes or scheduled tribes. That is why he gave that power to the parliament. Dr. B.R. So this particular judgment is contrary to the opinion of Dr. B.R. Ambedkar, what he expressed in the Constituent Assembly on 17th September 1949. This is also a crucial aspect we need to look at. This is one part of the judgment which is very, very disturbing. Now coming back to see one aspect when we look at this judgment or look at the evolution of the jurisprudence, the courts were invariably trying to only understand reservation, and there is, of course, reservation being the single way of a remedy that has been given to the scheduled caste and scheduled tribes, has become a very prominent and has become a very very important issue that was caught in the web of jurisprudence and court cases. The jurisprudence over the years for scheduled castes has not been very encouraging, in that sense that the too many cases were before the Supreme Court. Everything is about reservation only. Every case is about reservation only. And everything, in fact, we had 4 amendments to the Constitution. 4 amendments to the Constitution. Solely on the issue of reservation in promotion. In fact, every time Parliament gets in fact, Parliament stopped short of even making the other amendment on the basis of a case called Nagaraj in 2006. They did not amend. So the jurisprudence was too closeted into the aspect of reservation only. What Dr. Rehnamol wrote in her article is also very important, that why the other aspects of the Constitution are not looked into. The abolition of untouchability, in fact, what flows for the untouchables or the scheduled castes is that the flow of Article 15, where the governments are allowed to make any provisions for the scheduled castes, scheduled tribes and backward castes, Article 15.4, and Article 16.4, the government, there are 2 exceptions to 15 and 16, and also the articles for reservation in Assembly and Parliament. All these things flow from the fundamental right of Article 17. And we today or at any point in time cannot tamper with the scheduled castes. In fact, in the E.V. Chennaiah case, the word tampering was used. It tantamounts to tampering of the scheduled caste list, or maybe if it is extended, it extends to scheduled tribes. There cannot be any other factor except for untouchability for the inclusion or exclusion of the caste in the list. So therefore, what I'm trying to do is I'm limiting my talk only to this aspect of homogeneity or heterogeneity. Because what has happened, if you read the judgment, over the years there have been a successive series of judgments only on the aspect of reservation. Only on the reservation there have been so many judgments, various kinds of opinions that have been expressed in the Supreme Court and various expressions in the high courts. Or reservation should be like this, only one generation should get it. No. Once, in fact, there was a judgment on OBCs saying that since they are socially and educationally backward, once a backward caste person becomes a graduate, so his educational backwardness is finished. So therefore, his reservation should be finished. The, these are unfortunately what has happened while dealing with reservation. Over the period, the courts or individual judges had varying and extreme positions of on the how reservation should be implemented. So within that crux of how reservation should be implemented, the courts have gone so deep into all kinds of equality aspects, and in fact, the why I understand there is a huge hue and cry on this judgment is that this particular judgment has very far-reaching consequences. Far-reaching consequences not because they said that there can be a creamy layer and that the government of the day said that no, we will not accept this part of the judgment that on the creamy layer. It is not about that. The jurisprudence have gone to that extent that they have not gone to the core mandate of the Constitution on the abolition of untouchability, but they are only getting into the complete rigmarole of how reservation should be implemented, who should get it, which family should get it, which family should not get it. In fact, when you look at the entire remedy available to the to the scheduled castes or scheduled tribes, the remedy is available to it is a as a group. It is a group remedy. It is a group right. When it is a group right as a scheduled caste, when it is a group right as a scheduled tribe, and when it is a group right as other backward caste or social and educational backward caste, one cannot subdivide that group right. There is no such provision within the Constitution where it allows a subdivision of a group right. And even if to get into it, we need a constitutional amendment, even for this subgrouping of the scheduled castes or scheduled tribes, there has to be a pre-built provision within the Constitution to group. And so under 341, there is no such provision. So Supreme Court, one argument is available is that Supreme Court cannot create a provision. It can only interpret something. It cannot create a provision that is not available in the Constitution. What has happened in this judgment, which is very, very startling, is that it creates a provision which is not available. It's like this. So to this extent, so I want to limit my discussion today till here. Maybe I will be able to join or any other matter comes up. So these are the aspects which are hitting at the core or the root of scheduled caste. When suddenly the list says they are not homogeneous, it's a very basic pronouncement of the Supreme Court, hits at the very basic existence, at the roots of the very group called scheduled caste or very group called scheduled tribe. That is, creamy layer is of course an obiter dicta. It's a mentioning in the past. It has no value to the extent that of this judgment, because in this judgment neither creamy layer was argued nor it was an issue before the Supreme Court. So that is why it was very easy for the government of India to say that creamy layer cannot be imposed on scheduled castes and scheduled tribes. So since it was a passing or a very casual remark or a arbiter dicta of this judgment, so creamy layer is in fact an immaterial thing. But what happens is that there's too much of an argument and there's too much of a discussion in public domain on who should be creamy layer, who should be not. But that's a completely different thing. But what I understand and hits at the very root of existence of scheduled castes is that they are not homogeneous. So I'll stop here. Thank you, Subhajit. And as the discussion progresses, if I need it, I'll certainly intervene.
Thank you so much, sir, for sort of taking us through the whole processes of, or let's say, a little bit of archaeological, in fact, that how this entire, scheduled castes in various demographies, are present there. But at the same time, that on the again the point of homogeneity and heterogeneity, you have very poignantly, I would say, addressed that heterogeneity is quite a imposed, what should I say, the fiction. It's completely a fiction which has been imposed there. In fact, in one of the portion of the majority judgment of D.Y. Chandrachud, he talks about 15.4 and 16.4 of the Indian Constitution. And very interestingly, sir, 15.4 and 16.4 both are not in the original Constitution. 15.4 was added through the Constitution First Amendment Act 1951, and 16.4 again was 16.4 is there original.
16.4 amendments came later on.
Yeah, but
in the year 2000,
16.4 was the first thing. So, in fact, in the 16.4, which he mentions, Chandrachud, in the 16.4, there is no mention of SCs and STs. It talks about the backward classes only. So here is a very, very, as you rightly said, it's very, very startling the way this whole judgment has come out, and it kind of creates a new provision. Let's say I would call it a new fiction. I would just say one point, and then we'll hand over to Rehna. In one of the portion, Chandrachud writes, the principle of subclassification will be applicable to scheduled castes if the social positions of the constituents among the castes and groups is not comparable. So you are making hunches. This is not a solid base on which you are trying to make a subclassification argument. He further says subcategorization within a class is a constitutional requirement to secure substantive equality. How is it a constitutional requirement? He has gone on to cite other provisions, but how can you say it's a constitutional requirement? You have no nationwide study to look into the matter. You do not have, in fact, if I can say, caste census. Some people say the Arundhutiyas and Parayars discourse in Tamil Nadu. There are Kuruba boy yesterday. One of our very prominent activists from there, Salin Maria Lawrence, reported a Kuruba boy was murdered for getting married. So how do you say that? So this is the very relative and way of imposing your own fiction that some have gone ahead. How far and how less? How do you compare that sort of argument to come to a conclusion that subclassification? And Justice Chandru, the former judge of the Madras High Court, has rightly written that this entire criminal of SCST is a judicial invention. That whole article is very interesting. Anyways, but I would thank you, sir, once again for elaborately taking us through this whole judgment and your interpretation and how it's going to pose dangers in the future evolution of the jurisprudence related to this affirmative policies and so on. and how the SC/ST reservation can be tinkered later on. So, with further ado, I request Rehna for to deliver the lecture. And go ahead.
Thank you, Subhajit, for having me here in this program. As I think Sir has almost covered, especially the homogeneity versus heterogeneity debate in detail, that how historically the census reports and the commissioners have enumerated the caste on the basis of untouchability, and then how there was a formalized and systematic classification based on this factor. And the judgment clearly shows that it hasn't taken care of any of those historical factors in order to say that this category is homogeneous. And there itself comes a flow that without any proper examination or logic, the Supreme Court has come to a conclusion that it is heterogeneous, and then we have to subclassify the category. And before get I will be looking at more on the social and cultural and the structural aspects or the ramification of the judgment. But before getting into that, I will be also touching upon what Sir has said, the tinkering of the list in article 341A, right, 341A. So in that we can clearly, as Sir has mentioned, that in the Constituent Assembly debates also, Dr. B.R. Ambedkar was much more conscious about the fact that, or he was much more concerned about the fact that in future there should not be any political interference into that matter, or that particular category should not be subjected to any kind of a political compulsion. And that's what exactly he wanted, that the presidential list, or it has to be under the jurisdiction of the parliament, so that no state political parties on the basis of their electoral compulsion come and tinker with the list. But what Supreme Court has done through the judgment is that they have hampered that vision of Ambedkar, or that the concern that he had at point of time become much more grave at this point of time through this judgment, because the judgment says that the states have the power to make the jurisdiction accordingly as per the requirements. That means a free right being given to the states in order to deal with that list. That itself shows that the political parties, as per their political compulsion and choices, can tinker with this list, and that is something that we have to be really careful. So in this aspect also, the judgment becomes much more concerning for us, because it is now in the hands of the states to make the laws maybe as per their vote bank politics. And in that way also, it gives a kind of a huge threat to a huge threat to a unified movement. And apart from that, I'll also touch upon a little bit on the creamy layer. Even the judgment, the constitutional bench, in front of them, the case was Davinder Singh versus Punjab. All right. And there, the major appeal was that whether the Chinaya judgment is whether it holds any validity or not, whether subclassification possible or not. So that was a major concern of the bench, and regarding this particular aspect. But the bench has went a step. They not only has said that subclassification is possible, but they have given a judgment on a matter which was not under the jurisdiction or the purview, that is creamy layer. So that means, though the judgment, the constitutional bench was concerning about the subclassification, they have freely passed a judgment saying that it's we should include or introduce a creamy layer, and that too without being heard all the major stakeholders in this particular matter. So that itself shows that how the judges were already programmed in such a way that without having a proper examination of the matter, they have given the judgment. That itself shows that somehow, somewhere, this judgment is very motivated, especially in terms of coming up with a creamy layer. And then, moreover, while passing the judgment on creamy layer, what is the most the gravest concern is that they haven't looked at the social aspect, because in Indian society we know that the exploitation and the discrimination or the intersection of the problems, that's not only based on class, it is based on caste too. When you give a remedy or a solution for a particular problem, you will have to see the basis on which that particular problem arises, right? And when the caste is an issue, caste discrimination, caste based exploitation still exists, the court comes up saying that there should be a creamy layer based on the the financial status. That itself shows that how the caste factor complete being neglected, because even we all know that despite the upward mobility, how the marginalized sections still face caste discrimination. For example, we know that even the IAS officers or the professors, for that matter, any professionals who is having the upward mobility through reservation still face caste discrimination on their own, on their individual space. So, excluding creamy layer from the reservation and then saying that they have already gotten the upward mobility, what the court has completely neglected was that the existing discrimination, though, despite the fact that there was a kind of an economic mobility. And regarding this, there is another issue that arises is that, for instance, just let's imagine that creamy layer being excluded. So maybe through jobs they might have gotten the upward mobility, especially in terms of, they got the economic power, there must be an increase in the competitiveness of those people. But what is more important here is that despite having a mobility, despite having the competitiveness, despite having the merit, whether those people will be given a fair chance to compete with the people who are in the unreserved category or UR category. That is a major issue, because again, that is also not something that been taken care. That we all know that how the existing appointments, especially in universities and other educational institutions, happen, and there is a kind of a systematic and structural constraints on those people who have gotten into a kind of a space where their competitiveness have increased, their merit has been enhanced, but still they are not given a fair chance to compete with those who are in the UR category. So this also been not taken care. So in that way, we can say that creamy layer is something that is it was completely uncalled for, because the major factors was not taken into consideration. And now coming to the major aspect which I will be focusing on was that um, what is the impact of this particular subclassification judgment, especially on the factors of social or structural. And the judgment, there have been many people who are against the judgment, says that it actually divides the Dalit or the marginalized, because we have seen, I think the most probably Dalit movement could be the only unified movement we could see post independence, right? And here comes a judgment which actually dismantles that particular unified movement. But it's not just merely dividing Dalits, but it has far reaching consequences or far reaching ramification on an anti-caste movement. That's very important, because we all know that if you consider caste as unconstitutional or caste as a category which should be completely annihilated, in that context this judgment is something that is validating that caste category, which could be immoral or unethical or unconstitutional. So in other words, we can say that this judgment is legalizing the caste identities which we try to transcend the boundaries of, right? And we have also seen that unified. So in that way, uh, you know the people, the Hindu caste structure have imposed certain caste identities on you. And the judgment says that no, you have to mention your subcaste. That means you are again drawn into that mess of getting discrimination on the basis of the caste identities, not on the basis of your individual merit. And that means this judgment is also putting the anti-caste movement on a reverse gear. And whatever we have put the efforts into an allied caste is something that's been now stunted because of this subclassification judgment. In that way, the what the court is doing is that they are giving a legal validity to that traditional Hindu caste identity, which we really want to have the escape from. So in that way, I would argue that the subclassification judgment not just merely dividing the Dalits, but it is becoming an antithetical to anti-caste movement. And of course, that is again the vision, that is against the vision of Baba Sahib also, because we all know that, we as a unified movement transcend all those boundaries of caste, actually aspiring for a Begumpura, not a Ramarajya, right? Where the things will be based on the caste. For instance, if somebody is asking me what is your caste, I would not prefer to mention the Hindu imposed caste identity on me. I don't want to categorize myself as a Pulaya or a Paraya or a Chamar or Jatav or Mala or Madega. And that's something, that is something that I really want to escape from. But now through judiciary, now through the state institutions, we are compelled, we are pressurized to mention our caste identities, which we completely disapprove of, and that is a major issue. And very recently also there have been many if I'm not wrong, some of the application, and especially in admissions in some of the central universities, they already started giving this drop down menu where they have to mention the subcategory or subcaste. It's not subcategory. And I would also want to contrast this caste identity versus scheduled caste as a constitutional category. I think if we are having a self criticism of our own movement, I think one of the failures of our movement is that we could not create a kind of an anti caste consciousness. And that's an important point that has to be emphasized upon, because if you the way sir has mentioned that, there is a kind of a process and historical evolution of that particular category, and that category has become a constitutional category. It's scheduled caste, it's a constitutional category. And but here, like now we are no more into that constitutional category, rather we are now pushed into a Hindu categorization, which is much more problematic, and then we should resist against that. And now coming to my second aspect, which is how judiciary as an institution has been a den of casteism. I think we have seen very recently that there have been many resistance and voices against casteist collegium. And I personally did not understand what all are the major nuances or the major consequences of casteist collegium, because people have been talking about on social media for quite long. I didn't understand the intensity with which this particular institution actually works. But a close examination of judiciary and judicial pronouncement, or the history of jurisprudence on reservation, is quite shocking, because you look up to judiciary as an institution that ensures constitutional justice or upholds constitutional values, and the same institution is going against the kind of justice we always seek for from that particular institution. For instance, if you look at, especially if you look at the history of the jurisprudence, you can say that how the judiciary has become a den of casteism, starting from Chambagam Durai Rajan's case, and which actually led to an amendment, the first ever amendment in 1951. And in Chambagam Durai Rajan case, it was completely against the spirit of the reservation for the marginalized, and the parliament actually had to intervene to stop the judiciary to ensure reservation for the marginalized. So that itself shows that how judiciary been hostile towards reservation, especially based on caste. And in that way, if you look at the history of jurisprudence, we can see that how judiciary has largely remained hostile, if I say so, hostile to affirmative action. So you can see again the parliament coming in all the times as a savior of reservation of SCs and STs and OBCs. And I will just give a quick I will give a quick reference to some of the cases that actually shows that how the judiciary as an institution being hostile to this reservation. For example, B. Venkata Ramana versus State of Madras. In that case, also basically Madras Public Service Commission has reserved some of the seats for the in services based on caste. But again, there was a kind of a judgment saying that that is not something that we can approve of. Then you have another very notorious case, that is Balaji versus State of Mysore in 1962. So basically, in this particular case, also the state of Mysore, they have reserved 75% of seats for the backward classes, scheduled castes and scheduled tribes in admission. But what the Supreme Court has done was that it has ruled that this particular 75% is actually exceeding and it is actually excessive, and that was the first ever time the Supreme Court has kept the 50% cap on reservation, because they said that if you are giving affirmative action policies, especially in terms of admission exceeding 50%, it can undermine meritocracy and equality. So that is, again, you can see that how this particular judgment is so conditioned by certain caste prejudices and stigma. And they are essentializing through this judgment. They're not only putting the cap on the reservation, rather they are reaffirming that existing social stigma that SC, STs, OBCs are non-meritorious, right? So you can see that how, so that's what the very important factor here is, that you cannot separate the judges or the legal experts from their social location. They're coming from a social location which is conditioned by certain caste prejudices and stigma, which was completely evident in this particular case of Balaji versus State of Mysore in 1968. And that's what we have now, 50% cap. Of course, this 50% cap also be now exceeded through EWS reservation, which is again illegal as per this particular judgment. But again, that has been somehow somewhere accepted, because the state structures are in that way unfair in terms of ensuring the reservation as per the population. And then you have another case again in 1968, CA Rajendran versus Union of India. And basically, this particular case is the court has given the verdict saying that we have to restrict reservations to class third and fourth posts, because again, this is also very interesting. Why they're saying that we have to restrict the restrictions only to class third and fourth, because they think that the higher efficiency is needed for class one and class second. So if we are applying reservation, especially in promotion in this category, then that efficiency can be effective. Again, you can see that how the caste prejudices and the stigma played out in this particular case also. Then you have another famous notorious judgment, Indra Sani case in 1992. So especially in this infamous case, it has overruled that Rangachari judgment, and this judgment has also somehow somewhere indicated that how promotions would dilute efficiency in administration. And they have also said that if there is a kind of a relaxation in qualifying marks and promotion, that would also result in inefficiency and administration. So, and that's how they are saying that we cannot extend reservation in promotion. So again, you can see that how the judiciary as an institution is also validating and affirming those caste prejudices and stigma. And I mean, if again, if I personally also look into this particular case, and then like comparing my own experience, I would say that the people from SC, ST, OBC are much more meritorious and efficient than those who are coming in the non-reserved category. But again, if you look at another judgment in 1996, again Vinod Kumar judgment in 1996, where the court has again ruled against relaxation qualifying marks in matters of reservation and promotion. And this is what the history of judiciary, how they were not in favor of reservation based on caste, and then how they have emphasize upon the fact that, if there is a kind of a reservation, it will affect the efficiency and the merit of that particular post. And here comes the intervention of the parliament, and the history also says that, the parliament had to actually intervene several times in order to protect the reservation for the marginalized caste. For example, 77 amendment in 1995, which was again under Narasimha Rao government. He has amended the constitution to include the clause 4A into Article 16. The 16 4A, basically it permits the reservation for the scheduled castes and scheduled tribes in promotion. So again, you can see the tussle between the judiciary and the parliament, and maybe the parliament had to come up with that particular amendment because of the democratic politics. Because we have seen in Indian politics since 1990s, how there is a kind of a deepening of democracy and assertion of marginalized castes in the Indian political domain. So maybe under those kind of democratic compulsion, that in 1995, Narasimha Rao government had to bring the amendment which ensured the reservation for SCs and STs in promotion. And again, in order to nullify some of the judgments that came from the court, we had another amendment in 2000, especially 81st and 82nd amendment in 2000 had also to be done. And especially through 81st amendment, they have again inserted the article 164b in order to treat the backlog vacancies as a separate class. And that through that amendment, through that 81st amendment, which has incorporated 164b, it has allowed reservation promotion even if it reaches 50% ceiling on regular reservation, because the amendment has allowed state to carry forward the unfilled vacancies from previous years. Of course, this particular amendment was also later on known as carry forward rule. Basically, it was meant to fill up the backlog vacancies as a separate class. And then in 82nd amendment also by the parliament in 2000, a provision was included in article 335 through that 82nd amendment. And it has actually made to overcome the different aspects that's been given by Indira Sani and Vinod Kumar judgment. And then they said that, through this provision, the parliament had made it sure that article, whatever in the article in 335 does not prevent any of it doesn't prevent the state from relaxing the qualifying marks in any examination for reservation and promotion. And then in that way, through 82nd amendment, there was this amendment was actually made to continue the relaxation of qualifying marks. Then comes again 85th amendment. So you can see that how many times even the parliament also had to come in and then make make an amendment in order to nullify that judicial pronouncement that went against SCs and STs. In 85th amendment in 2001, which was done by third Vajpayee government, and it has subsequently amended 164A through 85th amendment. Basically, it has actually made to overcome a series of judgment which has made a rule of the consequential seniority in reservation. And they have said that this consequential seniority actually results in a reverse discrimination. But through 85th Constitution Amendment, a consequential seniority in case of promotion of SCs and STs employees were actually allowed. And as Vundru sir has said that there was again a Nagaraj case in 2006, and all the amendments made by the parliament again been changed in this particular case. So, what I'm trying to emphasize here is that at the jurisprudence, the history of jurisprudence on reservation, you can see a number of judicial pronouncement that coming against the reservation of SCs and STs, and which is much more a matter of a great concern, because like now ending up here in this particular subclassification judgment, that itself shows that even though creamy layer was not under their purview, still they have inserted creamy layer. So you can see that there is a kind of a pattern and tendency of judicial pronouncement that actually indicates that those judges are not in much in favor of the caste based reservation of affirmative action. And that's what I would come to the last point, that you have the last point is that we have to deal with this issue more comprehensively, because we have seen the struggle and movement of our people in order to fight out all the judicial pronouncement. And if we let it go, of course it will continue in future also. So what is more important here is how can we approach this particular issue, is that somehow somewhere we have to put an end to this collegium system. And that is also one of the major problem that lies in, because there is no adequate representation of SCs and STs and OBCs who have a lived experience of caste. And if we have certain judges who is giving pronouncement completely separated from those caste location, of course it is easier for them to just discredit the experiences of caste while they give the pronouncement on affirmative action. So in that way, it's not only this, the demand of our people or the movement should not be just about you amend the constitution and then you get away with the subclassification, get away with the creamy layer. Somehow somewhere we have to put an end to this through a huge demand for having a restructuring of the judiciary, especially in terms of the appointment, the mode of appointment. We have to ensure that there is adequate representation of SCs and STs and OBCs in this particular judiciary. And next major important point I would like to emphasize upon here is that this inclusion of reservation into 9 schedules, so that there should not be any more judicial intervention into this matter, because somehow someway we can put a stall on judicial interventions and interference into reservation, especially those judicial intervention which is not based on any kind of an empirical data. So and apart from that, as I said, this is not only something that like whether it's judicial structure, whether it's 9 schedule, it is more about having a consistent unified anti-caste movement. And this subclassification, I would say that it's a huge attack on anti-caste movement. And we have to, as I said, that we have to really envision for an egalitarian casteless Begumpura kind of a society, not a kind of a Ramrajya where we the individual merit is being overshadowed by what is your caste when you are born. So I will stop here. Thank you.
Okay. Thank you so much, Rehna, for taking us through this whole evolution of the things, and of course the collegium and the mode of appointment. I welcome Arvind for joining. I would go directly to him, but before that, I have been constantly trying to read or trying to decode this 565 pages that is there. If you read page number 72 onwards, in the where Chandrachud is referring Chinnaya, and Arvind has been kind of talking over the issues on various Twitter spaces, and he is one of the person who has started writing on the subclassification and so on. And of course, your article, Rena's own article. And in fact, this in the Chinnaya judgment, Justice Sema, the only probably in the history of the Supreme Court, the only Adivasi judge, he has written a beautiful judgment, very short judgment in the Chinnaya, where he says that once the caste those are put in the presidential list, they automatically become a homogeneous kind of class. So in fact, if you look at the Justice Hegde's point of view in the case of Chinnaya, he says that, and he is referring in N.M. Thomas, to hold that scheduled castes through drawn from various castes, races, and tribes attain a new status by the presidential notification, which is 341, 342 and onwards. So many things. Even I haven't gone to Mittal's portion. Mittal has been saying that during the era of Veda and so on, ancient period, there was no caste system, and now the caste system has become very different. So we'll probably, if we get time, we'll discuss that. In fact, if you look at Chinnaya N.V. Thomas bench, one of the judge was Justice Fajal Ali. He also observed that the scheduled castes and the scheduled tribes have been given a special status in the constitution, and they constitute a class by themselves. So is the case of Justice Mathu. Basically, the point that you were trying to hint at, that they themselves, this collegium system, and before that, they started creating judgment after judgment, and most of these cases also sometimes Arvind refers, and he says that they only create judgments after judgments, and on the basis of the previous judgments, they start building blocks. And this judgment would also be used to build further blocks to dent the SC/ST reservation. So, without further ado, I once again welcome Arvind for very quickly agreeing to the invitation. And I'm sure that I'm looking forward to Arvind's lecture, that he would surely be taking us through this whole, what you call, anathema of the process, and so on. So, Arvind, thanks. Please go ahead.
Thank you, Dr. Subhajit, and my apologies for late joining. I am out of London, and therefore, like I was walking through at some place, trying to find out better place to settle down, and finally I am in an office at some better place. But meanwhile, I was going through the comments which you have got on speeches of Dr. Raja Sekhar sir, and I find it really difficulty, like when learned person like Dr. Raja Sekhar Vundru has given a speech, and after that, if I have to place something, I don't think there would be anything left on which I will have to cover. But indeed, I will try to just give larger thought so that people can get the idea what has happened. Some of things might get repeated, which constantly I am saying. Of course, Rehna and the comment which, although I have not listened the speech of sir, I will later on listen. But the comment which I have read, I know sir has gone in very detail. As usual, he goes on. I know him very well since last 8-9 years. So largely, if in broader perspective, if we want to understand Indian judiciary, there is one very good book by Working with Indian Democracy. I think Working with Indian Constitution or Working with Indian Democracy, in which first chapter, I think, which is written by Granville Austin, I think, would have written first chapter. He begins with the statement that there has been, since independence, there has been a struggle for controlling over the constitution, controlling over Indian constitution, and that struggle is between the parliament and between judiciary. And he argued that that struggle somehow got settled in 1975 with the invention of basic structure doctrine, where judiciary took over control. Judiciary took over control on interpretation of the constitution, and parliament, the debate got settled on the parliament taking control on the amendment. But finally, judiciary has taken lead after 93 collegium judgment. It has gone much beyond. So with this power of interpretation, like taking control over the interpretation, problem which has started happening, like interpreting the constitution, when interpretation was limited when we read Constituent Assembly debate and those ideas, of course, judiciary has given power to review the laws or interpret the constitution in the context of laws and rule when they are first it is rule which are enacted by judiciary executive and then second is statutory authority, but second is the laws which legislative bodies enact. Now, so in one way, in first way, like judiciary took over reviewing from like laws, from rules to law, and then went on reviewing constituent amendments itself. We know that constituent amendment is one of very essential power of, like, it is called constituent power of parliament. And philosophically, globally, there has been debate between Jürgen Habermas and John Rawls over who owns power over reviewing, whether judiciary has power to review constituent amendments or not. I think Habermas said that it has power. Rawls said that no, it doesn't have power, because when parliament enacts, like parliament exercise its power of constituent power for amending, when it starts its power to amend the constitution, it becomes constituent assembly, like its status become constituent assembly. And when parliament becomes constituent assembly, like constituent assembly become alive. And when that become alive, it means that the doctrine of separation of power gets suspended at that time. So therefore, the amendments which are done through through amendments, the laws which are enacted through constituent amendments, those cannot be reviewed. But of course, we know that in India, it has not, like judiciary has not accepted that principle, and it has established control over constitution. Now that was one idea, like one way of enhancing power, and then now it has moved from 90s onward. It has moved from reviewing the constituent amendments to reviewing constitution itself. So the judgment which we are witnessing, instead of like examining the case which has come up before the court, instead of examining, like carefully, rigorously examining the case, it has gone on examining constitution provisions itself, putting new meaning in different articles of the constitution. And that's very dangerous, like trend which we are witnessing. And this trend, now legal scholars have also started pointing out this trend, that biggest threat which now we are witnessing in constitution is not coming from legislature or authoritarian government, but it is coming through interpretation of the constitution, interpretation by executive as well as interpretation by judiciary. And we know that 24 years ago there was attempt to review the constitution, and constitution review commission was established, but although that idea got abandoned, like commission got abandoned, its report was not implemented. But that review, now we see review has become alive, and judiciary has started reviewing a constitution. For example, in this case, it has used Article 142, I think 142, which gives its power that when there is no law, then you can like pronounce something for doing justice. But when there is law itself, so it was for law. Now they have started using it for changing the constitution itself. Tomorrow, like I am not surprised if the things goes in this way. Tomorrow they can say that, look, presidential form of democracy is much better than parliamentary form of the democracy. They can say anything. It is just matter of interpretation. So things can go up to that extent. So that's one big problem. And second larger problem is, which is related with this, if judiciary takes over the, if we allow judiciary taking over control over reviewing of the constitution, which means control by few families who appoint themselves, and they appoint themselves, and therefore controlling of certain family, or control of democracy by certain family. And these trends, like this kind of trends, have been largely discussed in the literature on democracy. I think Robert Dahl has discussed in one of his article, which right now I cannot remember, that he has discussed an idea called establishment. So he said that in every country there remains an establishment. For example, in Pakistan, army is establishment. So whatever happens, it happens around the army. And in our country, that judiciary has been becoming establishment. And judiciary means a certain family who are interlinked with each other, and country going in the direction where final authority would be vested in few families. So that's one big problem regarding this judgment. So that's one big idea, that that like they are taking control over that. When I am saying that, I am not saying that certain portion of the constitution cannot be amended at all. Like each and every article of the constitution, like the framers have formulated in the way that each and every article can be amended as per the demand, time, and circumstances, to make fit make fit for new situations which are arising, to solve the challenges which are arising. So, and when we say reservation, that is also applicable for reservation also. But problem in going in this way and going another way, it are two different things at all. Now, next issue, which Rehna has already discussed so many judgments, how like judiciary has gone through. So when we see judgments of judiciary from very first judgment itself, Champakam Durai Rajan, onward. So when we analyze taxation, we use formulation, whether it is regressive or whether it is progressive. And when we see judiciary's role in Indian politics, unless and until emergency was imposed. So when emergency was imposed, there were like few judges were seniority list was violated. That resulted like delivering some relatively progressive judgment. Prior to that, they were hell bent on like going for delivering regressive judgment, and they delivered regressive judgment in two domains. One was affirmative action policy, which was also, of course, meant for challenging the social hierarchy, social hierarchy of Indian society. Another was Land Reform Act. We can like stories after stories. We can have one judge in 1967. He in one day he just set Chief Justice and declared 5 land reform judgments unconstitutional. And in the evening he resigned. And in next morning he joined Party of Landlords, Swatantra Party, and contested presidential election. So judges has gone in that way, like they have misused their power in such a manner, and for like preventing, since Congress party during freedom struggle has promised that we will go for land reform, we will reform the land once we get the power. And so for committing, like for fulfilling their promise, they enacted they added schedule 9 in the Indian constitution. But such higher promises were not made for reservation, so they did not place reservation, like Pan India reservation in Schedule 9, but somehow they managed to do land reform. So when we see judiciary from that perspective, so two most important progressive policies which government was trying to introduce in post-colonial India, judiciary stand up one of the most important obstacle in those. And we cannot explain any, like, if we try to see why they have done, we cannot explain, it can't be explained with any other explanation doesn't come in my mind, except that judges were from feudal family during that time, or from extended feudal family. So law was limited to those. Even Baba Sahib Ambedkar was sent by Maharaja Gaikwad for studying. So feudal linkage with law has played very important role, like they were using that power to protect power, their power. I can imagine, like, if government would not have forcefully or brutally gone ahead, we might ended up living in the era of, like, we still have feudalism alive in its physical form, although it is in notional form. And Rehna referred Champakam Durai Rajan case. That case is important. It is important in one another way, because the judgment was delivered when first parliamentary election has not happened. And the amendment which was done by, like, first amendment when it was brought by, it was actually Constituent Assembly whose tenure has expired, but it was working as a interim parliament because election has not happened. And you can imagine, like, when every member of Constituent Assembly was alive, at that time, when they were working, at that time they delivered judgment saying that X and Y article are contrary to each other. Therefore, they said Article 15 and 16 are contrary to each other, or 16 and 14. Therefore, we nullify the provision of reservation. So they have gone in that way. When it came for going for delivering judgment, progressive judgment, for progressive policies which were meant for the empowering scheduled castes and scheduled tribe or other communities. So she had, like, rightly pointed out, enlisted. I will not go through all the judgments, but when you will read judgments from 1950s onward on reservation and make a, like, argument in this way, that whether this argument, acceptance of this argument will be beneficial for reserve category, and acceptance of argument or rejection of argument will be harmful for reserve category. You will find that in 90% cases, judiciary was, like, had jumped to accepting those arguments which were harmful for scheduled caste category. And because it has gone in this way, like my previous experience about all judgments suggests that that judiciary's approach has gone in this way, or when it delivered judgment later on it turned out. So immediately, like, my mind strikes. So if you deliver new judgment, I can be sure that it would be 100% or 99% harmful for these communities. Now, particularly with this judgment, largely one argument has been given, that it is going to benefit our logic, which has been given, that it is going to be benefit marginalized communities or left out communities. And when they have discussed that it is going to benefit the community, they did not discuss how roster will be implemented, which again came with their own judgment in 1995, when they just in one night they said that now from vacancy based roster, now you will have post based roster, or post based roster to vacancy based roster. Suddenly, with one judgment, like lakhs of seats which were vacant for scheduled castes and scheduled tribes, they got finished with because of that Sabharwal judgment on roster. They did not discuss how it is going to impact, or when we make any recommendation about the policy, consequence of policy is speculated. Without speculating consequence of the policy are nowadays what is called risk assessment. So without making any risk assessment, how can we say that this policy is going to be beneficial? And for making risk assessment, one idea was looking into the roster, how roster will be applicable, and whether it is going to reduce the number of the seat, or whether it is going to increase the number of the seats. So take for example, if we presently divide scheduled caste reservation, central government scheduled caste reservation in 3 categories, 5, 5, 5, and we implement it on roster. Presently, first seat, 7th number seats comes for scheduled caste, and if this reservation gets divided in three equal like portion, your seat will be 20, 21, 22. And imagine, unless and until in any department there are 19 seats, there won't be any scheduled caste person. And that's a very simple logic. Anyone can understand this. Divide it in 3 categories, no seat, like till 19 seats. So it is gonna to reduce the overall seat. The more division you will do with the reservation, more it will push the seat towards towards the end. And we know important positions like research institutions and other important positions where policy decisions are taken. You will not find more than like 18 or 20, 23. I take, for example, even if it goes to 25, then also it's a very problematic. So this is one of very like reduction in the number of seats due to roster. That's one of my very important objection to this judgment. So I am saying that what court is saying, that we are going to deliver justice. My aspersion is that they have calculated it in their mind, and they know that it is going to harm them. So using the language, but actually harming the community. That's one big problem which I find with this judgment, which it is gonna to do with the reservation. Third big problem is a possibility of promotion of discrimination, like increasing the intensity of discrimination. Like in 2001, there was a committee in Uttar Pradesh it was named Hukum Singh Committee. So Hukum Singh Committee made recommendation that scheduled castes should be divided in 2 categories, A and B. In A, Jato, Chamar, Dhusia, Jhusia, who are like subcaste of Chamar, they would be placed in category A, and remaining would be placed in category B. And similarly, OBC, they would be divided in 3 categories. In category A, there would be Yadavs. In category B, there would be more OBC, in which Jat, Kurmi, Lodh, Gujar, they would be placed, and remaining 3rd category would be most backward caste category. I think 66 castes were suggested that they would be in 3rd category. Now imagine if this division gets applied, and we know that if scheduled caste reservation is divided in 2 categories, in category A you have placed just Chamar. I am taking example of Uttar Pradesh. If we have placed Chamars, and in rest category we have placed remaining caste, and you call for interview for a person. Now, in present case, when you have 22% reservation, when all classes are there, unless and until candidate has not written Gautam, Bharti, Jato surname, there is very least possibility that person would be able to guess what is the exact caste of this person. Here you are placing them in a situation where person sitting in front of us will be 100% will be able to know that, look, this is the location of this person. This is the exact location of this caste. And when judges were discussing, I was surprised to notice that when they were discussing this idea that some castes are involved in unclean occupation, some castes are involved in clean occupation, why these things did not came in their mind? That when some upper caste would be recruiting, take for example, recruitment would be done for cook. Can anyone tell me that any cook on reserve seat has been appointed from Valmiki caste? Or from Musar, or from other caste who are still considered to be uncleaned and involved in different businesses? Because this kind of like disgust and what with good word is disgust gets comes up with exact location of the caste, and probably because of that Article 15 was added in the Constitution that you will have to ensure that caste-based discrimination should not get practiced. And here, judges are delivering a judgment which is making different caste, prone to be fallen in discrimination. And this we can further substantiate with one of the important research paper by Professor Thorat, which when he sent just application by different names, caste surnames having having same qualification, and ended up finding that people having lower caste surname was receiving less call for interview. And in my own research, like I have gone through looking into the candidates who uses caste specific surnames and who do not use caste specific surname, and I find that candidates who have used caste specific surname across the party line, they get 3% higher vote, and those candidates who do not use caste specific surname. So our society is caste conscious in that way. They are able to, there are many more research paper, one by Simon Chachar, who has done in terms of electoral studies, looking into whether people are conscious about castes, how people try to find out caste location of the people. What happens if they are able to exactly locate the caste of the person, and they come up with the idea that there are something called allied caste and from your own caste. So discrimination happens in this way also. And despite availability of plethora of literature in about discrimination of the caste, judges did not went on in those directions. They thought that okay, everything is fine. Every day they are getting news that seats are being declared not found suitable. Initially, not found suitable idea was invented only for like higher position nanoscience, molecular medicine, and from there it shifted in economics, statistics, mathematics, physics, and then it shifted in social sciences, economics, and political science, and in all those areas. Now it has gone in Hindi also. So in a country which claims to be national language is Hindi, now even they are not able to find out reserve category candidates, like suitable candidates to appoint it for Hindi assistant professors in Hindi also. So nothing can explain all these things except prevalence of the caste discrimination. And I find this judgment is gonna to further promote caste discrimination. And I have another empirical reason, partially empirical reason to believe is because this subclassification idea was implemented in Punjab and since 1975, and they gave 50% seats in scheduled caste. They gave preference to Majhabi and Valmikis, and that policy remained continued till it was declared, I think, unconstitutional in Devender Singh judgment. Like 30 to 30 year, more than 30 year that policy was implemented, remain implemented. Now, if policy was implemented for 30 years and still the state is saying that, look, Valmikis and Madhavis are backward among all scheduled castes. So, what happens to your policy, which you have implemented 30 years ago? Was it able to benefit somehow? And they gave data of 1971, I think. Despite knowing that, okay, when your policy was implemented in 1975, you should have looked into that what happens when we implemented the policy. Probably because of all these reasons, the idea of disgust and all these things which operate in the mind of like oppressor caste. So despite you can give, your intention might be good to give separate reservation to Valmiki, but you will end up in the same way. I never find any person like from Valmiki caste from like Punjab. I am unable to find out people like people on top position or important position, and I think these could be the reason rather than the reasons which were explained. And fourth point which I would like to point out is the way judgment has been delivered. It has potential to reduce equality of opportunity. So when judges were saying that scheduled caste, so even in liberal democracy, principle of equality of opportunity is considered to be cardinal principle. And under that principle, what has to be there? Every post which is available, which gets created, that should be available for the every member of the community. Now, Indian Constitution adds exception in Article 15 and says that for women and children, you can make like, you can have separate provision, special provision you can make. And in our constitution, when the constituent members have envisaged, they have thought in this way that if certain number of seats are reserved, are made for certain communities, it means that all seats, if one seat is reserved for the scheduled caste, it means that seat has to be open for the every member who is included in the scheduled caste, who are included in scheduled caste list. Now what government of Punjab has done, when it said that okay, Valmiki should be given 50% preference in the seats reserved for scheduled caste, under which constitutional provision they made that idea? There should be at least some constitutional provision. In what constitutional provision they came up? I didn't find, and it was direct violation of the article equality of opportunity principle, and judiciary didn't go on investigating that. So what I am saying that it should have gone. I am not saying that that kind of principle cannot be adopted. It can be adopted. Parliament can amend the constitution and add, like it has been added in Article 15, that for women and other children you can have special laws. So you can bring the amendment, but unless and until that kind of amendment, that kind of provisions are not there in the constitution, role of the judiciary is to strictly go for like strictly implement the equality of opportunity principle. But it has not gone like it has not investigated. It has not investigated that idea. And if they are saying that certain backward castes can be given more preference, that cannot be done without like adding something in Article 15, adding those exceptional clauses in Article 15. You elsewhere it is direct violation of it would be direct violation of equality of opportunity principle, and I will say like ending of the equality of opportunity principle. And the way judiciary has gone delivering one judgment particularly, EWS judgment, they have allowed it by declaring that Article 15 is not part of the basic structure and doctrine. So globally, like equality is defined through the principle of non-discrimination or through principle of non-discrimination or through principle of human right. The non-discrimination portion, courts has been trying to reduce that idea in Indian Constitution, and like social justice movement which began in 19th century, its foundational premise is to bring the idea of non-discrimination as an essential doctrine in Indian laws and in Indian law. Likewise, equality of opportunity principle, opening everything, every position for every community or each and every member of the society. That has also been one of important ideals which found place. Now, judiciary has been gradually like reducing the scope of that, and in this judgment it has gone way forward doing that. Lastly, there has been a lot of talk that if reservation provision gets inserted in Schedule 9, judiciary would not be able to intervene that. In this regard, just I want to clarify that probably in 2004 or 2005, they delivered a judgment saying that even if a law is placed in Schedule 9, judiciary has power to review that law. So when we are thinking that leaders are still in 1950s or 60s, they are thinking that Schedule 9 was added in Constitution to protect laws from like reviewed by judiciary. That is no longer the case. That's another idea. And lastly, like I would not go for like just saying giving all depressing news, but there is something positive also. And positive is this, that since like previously only mostly like employees used to fight the cases of scheduled caste, person like Raja Sekhar Vundru sir. But now, good thing is that with their action in Prevention of Atrocities Act, public has started taking cognizance of their judgment and has started fighting back. And because of the fight, I did not find like contemporary example in last 10 years where people have stood against judiciary judgment and they have forced the judiciary to take back their judgment. And in last 5 years, 2 times scheduled castes and scheduled tribe communities have done that. And first is Prevention of Atrocities Act, and second was roster judgment. And not only people have forced the judiciary to take back their decision, but also they have gone like they have become very conscious after that, after 2nd April protest. They have gone up to appointing 4 judges from scheduled caste, 1 from Dalit Christian background and 3 scheduled caste, and 2-3 OBC judges in High Court, Himachal Pradesh High Court, Karnataka High Court, Kerala High Court, and now Jammu Kashmir High Courts. They have appointed chief justices in the High Court from scheduled caste background. So change has started, like they have started realizing that, okay, people are challenging our decisions. And we are losing legitimacy. So all these fraud went until people kept saying that Milord hai, God ke avatar hai dharti pe. So all these kind of things till people believe. Till that time they were they went saying anything, doing whatever they wanted. But now biggest problem which they are facing is legitimacy crisis. And any institution can survive in democracy only unless and until people are ready to accept their rule. Baba Sahib Ambedkar, while referring Edmund Burke in Gandhi Ranade Jinnah, has said that law can survive till the people are ready to accept. And judicial pronouncements are nothing but law. And it will survive till the people will accept it. And it will not survive if people refuse to accept it. And that possibility, now I have started witnessing that possibility in our country. And 2 months ago, Chief Justice D.Y. Chanchud was in Cambridge University, and I went there, and he was saying everything, that taking some petty example on environment and one petty judgment on providing food, and saying that, look how progressive our judiciary has been for the poor people, for the marginalized communities. And I asked him, so if you are so much concerned about marginalized communities and poor communities, give me an example where we have find out like why people in India, marginalized community, stood up against you in two judgments. Because of that, you have to take back your judgment, and give me example where anywhere other in the other part of the world where such thing has happened. And he said, look, error can happen, and we have rectified our error. So they accepted that their error happened, but unfortunately, they rectified their error. Cost of that rectification is 14 life of young people. So that cost a community has to bear. But what I find that they know, they are very well aware, and I have said this thing in that interaction, that I see, because he has discussed that we are contemplating to deliver judgment in this way, looking in this way, whether idea, scheduled caste and scheduled tribe list can be further categorized to deliver justice. At that time, I said that, look, I see similar similar consequences in upcoming days. You might face, Indian judiciary might face, if it keeps going on in that direction. So I am hopeful in this way, though it might be possible that on this occasion people might not be able to push judiciary back, but up to some extent they have been able to already push, because government has already announced that we are not going to implement creamy layer principle. So half of the judgment is gone. Only half of the judgment is aliving. So now why judiciary will deliver judgment? Why should it go in delivering a kind of judgment? If I would have been judge, why I will deliver a judgment if I know that my judgment is not going to be implemented? So by acquiring power, they have gone up to that extent where they are facing legitimacy crisis, and somehow one can think in this way also, that okay, like in future they will not be delivering wrong judgment towards judiciary, or it will somehow it will open a space for democratization of judiciary. But another way, we shall also be like conscious that if a highest court's judgment, highest court of the country comes under legitimacy crisis, that is, it might have severe consequences for the sustainability of democracy also. So with this, I will conclude. Thank you, Subhajit, and everyone for like listening me, and particularly Raja Sekhar Vundru sir, like you have stayed more than how many hours? It would be probably 1.5 hours if what does my time say. So thank you, everyone.
I cleared 2 files during the time.
Sir?
So,
I was doing work. Anyway, very nice.
yeah.
I think instead of Subhajit saying it, Arvind has been now, if they were hitting at the root of the very existence of scheduled caste, Arvind is trying to hit at the very root of the judicial existence, in the sense that how the conflict between the constitution and the constitution makers very beautifully put across. And one aspect which we would have not otherwise looked at is how the roster would operate. One more thing which he had hit at is Article 15.1, where Article 15.1 comes in conflict with the subcategorization. And actually, I remember when I was a director in the Ministry of Social Justice, this E.V. Chinnaya judgment came. So when the E.V. Chinnaya judgment came, there were several representations from both sides, especially because it was an Andhra case. So I was the director dealing with the matter. So I wrote a 14-page note on the various representations received from both the sides, Mala and Madiga. And as I read through the judgment, E.V. Chinnaya was very interesting to the extent they said that this particular subcategorization hits Article 14, 15 and 16, the basic core aspect. They said they felt that it was a violation. So in that note, I wrote a paragraph that if it hits Article 14, 15 and 16, it hits the basic structure of the Constitution. So when my note was sent to the Attorney General, so Attorney General wrote back a note in reply to the file which we sent. So I said that the government should accept E.V. Chinnaya. So AG wrote a note that yes, it is agreed that it hits at the basic structure of the Constitution. If it hits 14, 15, 16, it hits at the basic structure of the Constitution. But the AG also referred to Indira Sani. He said Indira Sani judgment was negated, a part of the Indira Sani judgment was negated by the government by bringing in the 77th Amendment to the Constitution on reservation and promotion for scheduled castes. So the AG wrote a part of the note that saying that if government wants, they can further go ahead and bring in subcategorization, but to bring in that, they need to create such a kind of an evidence. The government needs to create an evidence which will sustain judicial scrutiny. So at that time, Meera Kumar was the minister. She was very keen on subcategorization because she was supporting Madigas of Andhra Pradesh, very strangely. She being a Chamar of Bihar, supporting Madigas of Andhra was very strange for other reasons. So then the government decided to constitute a commission. One, why am I forgetting the name of that lady justice of Delhi, Usha Mehra Commission. So the Usha Mehra Commission went around. Usha Mehra Commission went around and then it collected evidence as per the advice of the AG. So when the report was being prepared, suddenly the government, Meera Kumar called her and told her that please submit a report in favor of subcategorization. So contrary to the evidence on the report, Usha Mehra in the last para, where the evidence is contrary, but Usha Mehra in the last para wrote, the states can subcategorize only in Andhra Pradesh. That was the recommendation. But other states want, they can do. So now the procedure when a commission report comes, the commission report was sent to, by the time this Maharashtrian guy became the minister for social justice. So the report was sent to all the states. for their comments. And there was disagreement by majority of the states, and the states refused to subcategorize. And also, as Arvind has mentioned, the SC Commission itself refused. It did not agree with subcategory. So what the constitutional process and the process within the system has been subverted and set aside and sidelined by this judgment. Here is a report called Usha Mehra Commission report. The report is being examined. Now, any amendment, any aspect that, of course, here SC Commission in itself is a constitutional commission in itself is, short-shrifted and set aside. The opinion of the constitutional SC Commission was never taken into consideration by the Supreme Court, never taken into consideration. But at the same time, for example, what happens when we extend every 10 years the reservation for assemblies and Lok Sabha? Suddenly in Haryana, they called assembly for 1 day. So we were all thinking that what was the sole reason was at the time when the extension of 10 years of reservation in Parliament and Assembly. So every assembly had to endorse. Yes. Every state assembly had to endorse the 10 years of extension. So that means in the matters of scheduled caste and scheduled tribes, it is not that a Supreme Court 6 out of 7 people gives you a judgment. And anything that hits at 341, anything that hits at 341 has to be accepted by the states. But even if I make an amendment, tomorrow if the government thinks that, okay, based on the Supreme Court, government thinks that it agrees with subcategorization and it amends, say, 341, say for example. Now that amendment has to be accepted by every state of this country because the scheduled caste implementation of whatever of the 15.4 or 16.4 of the scheduled caste are by the states. So there is a whole process involved which has been ignored and sidelined by the judgment. So this judgment in itself is not agreeable to majority of the people, because if somebody gives a judgment of 555 pages, even serious academicians like Dr. Rehnamol, Dr. Arvind and Dr. Subhajit Naskar will take some time to read it. Forget about the other political parties. One cannot deliver a judgment which is like a fat book of Ambedkar's volume 10. It's such a fat book and you need to understand it. One has to take time, read it, and if people start reading it, they will understand how much, as Arvind said, how much misinformation is used, how much irrelevant information is used to arrive at whatever decision they have arrived. It is not the what decision you arrive at, and what is the substance on the basis of which you are arriving at a decision is also important. So that is where I think I am very much and highly, in fact, we should thank Subhajit for pulling Arvind from his walking streets of London and makes him sit somewhere. And, we were all cozily sitting in sort of Delhi, Chandigarh and Calcutta. So thank you so much for joining, and it's a very beautiful intervention of yours. Thank you. Over to Subhajit.
Thank you so much, sir. I think just last comments if Arvind and Rena can want to make, but there's one thing that I see in the judgment where Justice Mittal is summarizing so many of the state commissions. Janardhanam committee which Karunanidhi constituted, then Mahadalit Commission that Nitish Kumar constituted, and then Ramchandran Raju Committee that Chandrababu Naidu constituted. But the point is that we all in political science, legal landscape, sociological studies understand how these committees and when these committees are constituted by these political leaders. Right?
Yes, like the politics of commission is very strange in our country.
Yes, yes.
And we have seen in Godhra case, one commission said कि जो है वो तो आग ट्रेन में खाना बनाते हुए लग गई और खाना बनाते हुए 40 लोग जो है आग में भुन गए और another commission said कि
Yes, so there is some network problem. Yeah. Arvind, are you back? So,
point
yeah.
commission.
Mm.
Yeah.
Yeah, so this is probably one case. In fact, Nitish Kumar's Mahadalit Commission of 2007 is being taken, has come under scrutiny by the caste census of Bihar. If you look at the caste census result of Bihar, Mahadalit Commission, the way they have put in so many weaker sections in the through that Mahadalit Commission, even the non-so-called quote-unquote Mahadalits, they are also very poor. They are also facing discriminations. They are facing gang rape, those Dalit communities. So the point that I'm saying that this whole puzzle, that probably this whole premise this Supreme Court has created, even so many academics in the white academicians, even in our country, that they always take the premise of inter caste. And this is very baffling. You are living in a society which is organized around a Hindu fourfold order. And in the Hindu fourfold caste order, you are trying to analyze caste within SCs, which is out of the caste, which is the Avarna category. And Rena was constantly trying to give a hint at it through her tweets. So you are trying to put caste into a casteless category, yeah, which is scheduled caste, isn't it? Yeah.
Yeah, Subhajit. So now, like, even for smaller policies, and forget about larger policies which are going to impact the people, for pursuing a PhD research, for pursuing a empirical PhD research, which will not impact anyone, but only it impacts a student. So what is done nowadays, instead of pushing candidate to go start doing PhD and end up in 5 years finding nothing, normal practice has become to push the candidate for first conduct a pilot study. See whether what you are proposing, how does it exist. In this case, even like strange, a normal person who would have been thinking that, okay, we have a case, thinking that if we accept these two policies, these, like, one policy is subcategorization, one policy is giving preference. So if I have to test this, suggest that, okay, these policies are gonna to benefit, they could have gone into looking whether this policy has worked or it has not worked. And in Bihar, they have good example of having this policy, like subcategorization policy, implemented there. So Nitish Kumar first implemented the policy and subcategorized caste in two groups, Dalits and Mahadalit. So after 2-3 years, he took one caste from Dalit category and placed it back in Mahadalit. And in the end, in 2015, it ended up putting all caste in Mahadalit category. So now
So they're all scheduled caste.
So all scheduled caste are there, Mahadalit only. Nomenclature has been changed. Why he did that? Because subcategorization was not working at all. And, like, I should not use some rough word, but if judges would have some, like, sound-minded person, any sound-minded person will think that first it should have asked that, okay, if this policy has not worked in Bihar, how can we implement this policy in whole country? And similarly, I am saying that the subclassification where priority is given to particular caste, that policy is implemented in Punjab. They could have asked the Punjab government, okay, what is the status of the caste whom you have placed at in first priority? Though placing one caste on priority is problematic because of theoretically it promotes a discrimination, violation of Article 15, as well as secondly it violates equality of opportunity principle of all castes which are included. And besides that, if you say that Valmikis and Ravidasis there in Punjab, Valmikis are weaker and Ravidasis are stronger, so we should give priority to Ravidasi. Valmikis, what about other castes there who are like Chidimar and Kanjar? They might not be their existence might be at the question. Can they remain with their same premise? Can they remain with can they compete with the Ravidasis with whom they have been placed, or they have been placed under second priority list in Punjab? So all these were like they had example, but did not go of taking even those examples, and that suggests like ideological biasness. One, I think Sanjay Hegde has written, he tweeted, because he argued in the case, he said that judgment is like WhatsApp gossip. So whatever WhatsApp gossip we listen, we should place everything in the judgment because we have
Sanjay Hegde during the judgment, during from the respondent side when he was deposing, he made a very interesting comment. He says that if you subclassify it, you are reversing repran pratishtha. During those days this Ram Mandir thing was going on. He says that you are re-establishing reaffirming pran pratishtha. So pran pratishtha of the caste. So you are reaffirming caste within a casteless section, on which everybody laughed, but they couldn't digest properly very well. But anyways, this is as a result of this judgment. In fact, the lateral entry notification at the right from Deputy Secretary, Joint Secretary, have you seen that even Pankaj Mittal is hinting at it in his small section. But what I found is that all these commissions that they are taking into cognizance, from Chandrachud to Mittal to Gawai and others, I mean, none of these commissions are being re-evaluated. How far the commissions, whatever the commission has done, the commission's prescriptions have been accepted, whether in the case of Tamil Nadu, whether in the case of Punjab, Bihar. In the Bihar, it's been reversed back, as Arvind, you were saying. So in the case of, yesterday I was talking to Salin, she was saying, Kuruba, what about the malas? So none of the malas are facing discrimination. Should we take that as a face value? In a case of recently, the Vice Chancellor's appointments case is going on in the Supreme Court from the Bengal. Some 40-50 Vice Chancellors posts. So Governor is not agreeing with the Chief Ministers and the Higher Education Minister. So the UGC rule is again coming under scrutiny. So both the parties have gone to the Supreme Court. And every time Supreme Court says that, you try to create some kind of formula between the CM and Governor. Governor wouldn't sit with the CM. You know what is into the political things. So now Supreme Court has said that both of you, Governor and the CM, both of you give us a list of selection committees of the Vice Chancellors. Now, from the political side of the Chief Minister has given a list of the people, those would be the selection list people, those would be selecting the Vice Chancellors. So many of those names are not scrutinized by the Supreme Court division bench. What they have done, some of these names have corruption charges against them prima facie. And Supreme Court has accepted it. Now these men would be sitting, and grievous corruption charges when they were Vice Chancellors, Pro-Vice Chancellors, they would be sitting to select the Vice Chancellors, and Supreme Court has said that, yeah, go ahead. So Supreme Court in the similar fashion is taking into cognizance these commissions, where Supreme Court has not gone into the details whether the commission's recommendations and prescriptions after the approval by the states, what is the audit what has happened after the materialization of these commission reports? And in most of these cases, these commission reports are found to be very political, and none of these commissions are being made through social movements by the within the SCCAs. These are being the committees; those are being made by the political men holding power, whosoever is ruling. So this is why Sanjay Hegde said that there would be political tinkering of the SC/ST list once you leave it to
I would,
the.
in fact, I'm opening this constitution debates 18th May 1951. The first amendment bill was moved, and Ambedkar was talking about the bill he moved. And he was talking about the Champakam Dorai Rajan case. He says, I have carefully studied both the judgments of the Supreme Court. And with all respect to the judges of the Supreme Court, I cannot help to say they find this judgment to be utterly unsatisfactory. This was actually published on the next day of all the newspapers, saying that Ambedkar has criticized the Supreme Court. So then one Naziruddin Ahmad from Bengal says, point of order, that the member is expressing disrespect to the highest judiciary in the land. It is in the custom of the parliament not to speak disparagingly about. Ambedkar says, there is no disparagement of the learned judges at all. The judgment does not appear to be in consonance with the articles of the Constitution. That is my point. See, in fact, Ambedkar openly criticizes in the Champakam Dorai Rajan case. Ambedkar came out, and in the next day newspapers, it was all over the newspaper. Ambedkar has criticized the judge. Now it is time. It is time we should say the judgment does not appear to be in consonance with the articles of the Constitution.
Yes. And sir, just to add, like Champakam Durai Rajan has created such a dissatisfaction in the government at that time that government has considered appointing Chief Justice someone outside from the Supreme Court. So name of first Attorney General, Sital Ward's name was considered, and he said that I have crossed the retirement age limit, so I should not be, I can't be appointed. And after listening this conversation which were going in the government that Chief Justice would be appointed from someone like government outside of the judiciary, so all judges went to wrote Jawaharlal Nehru saying that if Chief Justice gets appointed from outside of the court, all judges of Supreme Court will tender their resignation. So because of that, they have government has surrendered because of their threat for resignation, en masse resignation. Government has surrendered. But sir is absolutely right that there was government, because they have made the constitution. So those who have made the constitution, they know better what is the meaning of the constitution, article 14, or how it would be applicable. I have read somewhere that Jawaharlal Nehru was under consideration that someone who was part of the Constituent Assembly should be made the Chief Justice rather than these judges who were coming from outside. So these were concerns going on. Yeah, thanks, sir.
Yeah, so we are coming to close, but one thing, sir, if this judgment stays and is not overruled in the parliament, EWS does not survive. EWS does not survive. The Chandrachud, when EWS review petition was filed, this is the same Chandrachud, Justice Chandrachud, who rejected. Rana tweeted about it. And EWS and this judgment that Chandrachud wrote is completely in contradiction. Yeah. I mean, you need to also subclassify EWS also. So you have violated Article 15. Whereas you are not giving anyone, you are SCs, STs, OBCs, you have created a completely, it's like a closed caste unit that Dr. Ambedkar said in caste mechanism and that 1916 lecture at Columbia University. So you have created EWS as a very close unit. you also do not when the Bihar case of when the cap was extended after the caste census, when it came to Supreme Court, they turned it down. They said they agreed with the Bihar High Court, Patna High Court. And on the same case, you also, I mean, see the contradiction. In the case of EWS, they can just remove the cap and go ahead.
I think judiciary is very confused. They should leave it to the parliament.
Yes, that's the, yeah. In fact, I would end with the short note of Justice Bela Trivedi, the only judge who gave a dissent. And she writes in page number 81 of her judgment, she says, and this I'm sure very contextual to what we are discussing, and I'm sure Sir, Rehna and Arvind would agree. The action of the state, and I'm quoting, the action of the state, though well-intentioned and affirmative in nature, though, there is a though, if violates the specific provision of the Constitution, cannot be validated by the Supreme Court in exercise of his jurisdiction under Article 142. And this is very interesting, very strong counter to rest of these judges. And she says the removal of inequalities or remedy to remove inequalities cannot be permitted at the cost of violation of the specific provision of the Constitution.
Yes.
And so you are applying something which would be violating something else further. And she further says, when the wordings of the provision of the statutes in the instant case of Article 341 of the Constitution are clear, as also the intention of the draftsman of the Constitution, that means Constituent Assembly, the court cannot add or subtract words from such provision to give it a meaning which the court feels would achieve the goal of social transformation. Sometimes the affirmative action and the Constitution intersect with each other in complex ways, as the affirmative action policies are framed by the states to promote diversity and to address historical inequalities, while the legal frameworks have to ensure that these policies are implemented within the bounds of the Constitution of India. I think this summarizes the whole point, that how subclassification would be violating these basic principles enshrined in the Constitution of India by the Constitution makers. Anyways, if there is any last words that you wanted to say, I would start with Rehna, and then you can take few minutes or maybe 1
No,
minute.
I've said what I said. In fact, I think Dr. Rehnamol should have the last word.
Yeah.
Voice.
Yeah. Unmute. You need to unmute.
At this time, I find it would be more challenging because unlike 2018, when the judgment came diluting SC/ST Atrocities Act, it was a unified movement. But this time, the community itself is divided on this particular issue. So, forming an opinion which is universal in nature is much more difficult. So that is one of the challenges that I feel like we have to tackle with. And as I said, the judicial pronouncement and the amendments, this time both the judiciary and the parliament is in consonance in terms of having the subclassification. So that will be another difficult thing to address. And but I feel like there should be more discussions, deliberation on this, so that we can have a convincing public opinion. And also those political parties who are ambiguous, especially those political parties who claim addressing the aspiration of Dalits, they should not remain ambiguous. Rather, they should come up with their own clear opinion, so that I think more pressure should be put on those political parties, so that we can have a unified public opinion and then resist against it. That would be my last words.
Thank you so much. Arvind, any last words?
Arvind is walking back home.
Okay, so Arvind, should we would you, I think Arvind has muted and probably, hello, Arvind? Yeah, would you like to have some last words?
Yeah, so of course I agree.
On collegium, probably.
Yeah, so Miss, Sir, what time I took for like arguing probably half hour, sir, just submit. He
Summarized.
summarizes in he has summarized in just one sentence that judiciary was going behind, like for last 50, 70 years, it was going behind scheduled caste, scheduled tribe and OBC communities. Now trend has reversed. And trend has reversed in such a way that I have been informed from government side that judges are writing that people are writing against us and you should start considering taking action. And government has communicated that it is there. It is freedom of speech of citizens, whatever they want. We cannot go behind that. So what I see, sir rightly said that now people has started chasing. So when I see, even like though there might not be unified movement, but the question, if any section of the community stands against judiciary, it is gonna to challenge, it is gonna to bring legitimacy crisis to judiciary. Despite its judgment might sustain, despite having protest and all those things, having lot of criticism. But even criticism, raising aspersion on judges, writing against them, criticism of questioning their intention, everything, every word which will be said against against this judgment in public domain is gonna to reduce the trust and trust in judiciary, impartiality in their judgment, and it will bring crisis for judiciary. So that's my last comment. Yeah.
I think Sir has already said. Okay, Sir.
Yeah, I think we should wind up.
Yeah. Okay. So thank you so much. I think again, I have been, whenever I have been inviting Sir, Sir has never turned it down. Probably this is one occasion when Sir can never turn it down. So I would be, so I would be nagging behind Sir that you should be on the panel, and I would thank Arvind that probably he is on invitation or somewhere, so I have brought him back from there. And
See, this is an international conference now.
Yes.
From London to Calcutta to Delhi to Chandigarh.
Yes, and of course, my old friend Rena, and of course, this so many of JNUites here, so raising very challenging questions. And of course, thank you so much, everyone, for.
Thank you. Thank you for holding this.
Yeah.
Thank you.
Thank you, sir.
Bye-bye.
Thank you.
Thank you.
Bye.
Thank you, Arvind. Yes. We are ending, Tapos. Okay, end it. Yes.